All right, welcome everyone to another YMCA Education Series talk. My name is Pam Rakanski. I'm the YMCA Education Series facilitator. Today we are hearing about Estate Planning 101 from Matt Margolis. Trusts aren't just for Pritzkers. So elder law attorney Matt Margolis will teach us about the importance of estate planning no matter our level of wealth. This discussion will cover what is important to include in the estate planning and how to use trusts and other tools to protect your loved ones. So with that being said, Matt will take questions. You feel free to put them in the chat box. Otherwise, he will take the questions more towards the end. He'll save about like 10 minutes, 5-10 minutes at the end for questions. With that being said, we'd like to welcome Matt Margolis. Welcome.
Thanks, Pam. Woo. All right. Good morning. Good to see two faces other than Pam. So thank you. Those brave souls showing me your face. Yeah. So to kind of give you guys a little bit of background on me and my firm. So I've been doing these talks now for, boy, I probably should keep track actually. I want to say probably the last 7 years or so, maybe since the start of the, I don't know if it was the start of the program necessarily, but all I know is I think the first talk I ever gave was I think it was the morning that we found out that Donald Trump was elected president. So whenever that was, that's the first morning I ever gave a talk with YMCA. So my partner Lauren Weldon and I have a boutique estate planning and elder law practice. We're in downtown Park Ridge, even though I'm a Northbrook resident. So we help folks, and my practice kind of concentrates more on the estate planning side, helping individuals with wills, trusts, powers of attorney. We do some I do a little bit of asset protection. We do a little bit of special needs planning. And then the other half of the practice, which my partner kind of takes over for the most part, even though we both do all of it, is more of the elder law side. So we do a lot of Medicaid. We help people apply for Medicaid. We help them protect assets when moving into nursing homes and supportive living facilities, and just really counseling individuals that are, from a legal and financial standpoint, that are, kind of going through a long-term care transition, and just trying to help them figure things out and make sure that they're, saving money if they can, or at least making the right decisions. So that's kind of us. That's what we do. We've got two staff, Mike and Natalie. They're fantastic. Yeah, I'm married. I've got two little kids that are in the Northbrook schools. So maybe I'll see some of you around depending on where you live, but I only see one face. So, that you're the only person that maybe I'll see around. All right. So today's talk, Estate Planning 101, trusts aren't just for the Pritzkers. So I hope everybody knows who the Pritzkers are. If you don't, you've been living under a rock. And I kind of joke around with the title because I think a lot of people have this idea that trusts are just for wealthy people. I think a lot of people that have never taken, not necessarily taken the time in a bad way, but just a lot of people that maybe haven't explored any estate planning, haven't done any research on estate planning. Most of us can, kind of look at like the movies that we watch and the TV shows, and maybe we went to college or high school with a trust fund kid. And so we have this idea that the trusts are just for people with lots of money. And hopefully after today's talk, you will realize that is absolutely not the case. And I can tell you right now that it is not. The materials that we'll cover today are really sort of basic estate planning documents. And when I say basic, I shouldn't say basic. I should say more traditional estate planning documents. We're going to talk about wills. We're going to talk about trusts. We're going to talk about trusts more than wills. We're going to talk about powers of attorney for healthcare and property and HIPAAs and living wills. And really all these documents we're going to talk about today are really the documents that make up traditional estate plans. Okay, so when we talk about, we look at, our parents or grandparents that put a plan together, or we think about ourselves and we think, oh gosh, we should really do some planning, right? We've got young kids that are under 18, maybe they're over 18 at this point. We don't have a plan in place. The documents I'm going to discuss today are really, when we look at an estate plan for an individual or a couple, these are the documents that 99% of people are going to be putting together, okay, or some version of them. And lastly, the information you guys are all going to hear today from me, and really the way that I present it, is identical to if you called my office and you said, Matt, you know what, I want to come in and discuss what an estate plan might look like for me or for me and my spouse. Honestly, what we will cover today is identical to that. So much so that I now use a link from one of these talks that I've given in the past. And when potential clients reach out, and maybe we can't match up our hours to meet, I've sent them the link so that they can, kind of in lieu of having an initial meeting, they can watch this talk that I give. And it's identical to what I would discuss with them if they came into the office. Truly, it's the same material. So, all right, let's talk about some planning, right? So when we look at planning, there's sort of two main paths that we can go down. All right, so we've got the idea of a last will and testament, and then the idea of a trust. And we're really going to talk about a will first. So, like many of you, I've got some stuff, right? And we all have our own version of stuff. So, I'm going to guess most people that are watching this today, maybe they've got a checking account or a savings account or a brokerage account, maybe an IRA or a 401k. Maybe you've got some life insurance. Maybe you own a home or a condo. Maybe you're fortunate enough to own a second property somewhere, right? And so I would argue that we all have something that I just mentioned, whether it's all of that, whether it's some of it. So we've all got some stuff. And, really when we talk about planning, for the most part, unless we've got minor children, and obviously we're concerned about who would care for them if something happened to us. For most people, when they're talking about estate planning, what are we talking about? We're talking about where does our stuff go when we die, right? And I hate to break it to everybody, but we all have an expiration date, right? I don't like to admit it, but we're not going to be here forever. And so we need to plan for that. And most people care about where their stuff goes when they die. I've been doing this for 12 years. I've worked with thousands of clients. I can tell you that it's very uncommon for me to meet with somebody that truly doesn't care where their stuff goes when they die. Okay. I think there's been like one person in 12 years, and I can actually picture who he was. I don't know his name. I forget that at this point, but most people care. So I've got some stuff, and at some point I'm going to pass away. And so ultimately there is a process in place in the state of Illinois that will dictate where my stuff goes when I die. Okay. And that process, and don't everybody raise your hand at once, and I can't see them anyway, so it doesn't matter. But that process is called probate. Okay. And maybe some of you have heard of this process. Maybe some of you have dealt with this process when a loved one passed away. But ultimately, probate is a court process. And, we have this in probate, there's a judge, and the judge determines, based on the laws of Illinois, where our stuff goes. Who gets it? How do they get it? When do they get it? Okay. Now, the reason why an estate will go through probate when somebody passes away is if, and we'll talk about me, let's just talk about me dying. It's a lot easier for me to talk from that standpoint. So the reason why my estate would go through probate is if at the time I die, there are assets in my name only that are not in a trust, we'll talk about a trust, that are not owned jointly with somebody else, and that do not have a beneficiary on them. Okay. So the reason why an asset would go through probate is that it's not in a trust, it's not owned jointly with somebody, and there's no beneficiary on it. That and then those assets would go through probate. So if I have an IRA with beneficiaries that survive me, and I say that survive me because we've had individuals come to us, not that we did any planning for, but we've had children of individuals who have passed away where they had their spouse named as the beneficiary of their IRA, and their spouse died 10 years before them, and they never updated their beneficiaries. Well, that's as good as having no beneficiary. I hope that's clear. Same with a life insurance policy. So if I've got IRAs and life insurance policies with beneficiaries named on them, those don't go through probate. But if I've got a house in my name only, when I die, the house will go through probate. If I've got a checking account at Bank of America with $100,000 in it, it's going to go through probate. Okay. So some of my stuff can go through probate and some of my stuff may not go through probate. Okay. It's not like it's all or nothing. I just want to make sure everybody understands that. Right. There might be some aspects of my estate that avoid it, some aspects that don't. Okay. Now let's back up for a second. A lot of married couples, even without any planning, avoid probate. Okay. And they kind of avoid probate by default. And I'm not going to give them any credit that they were doing it on purpose, right? But a lot of married couples tend to own things jointly, right? My wife and I, before we did any planning, everything was owned jointly, or we were beneficiaries for one another, right? So we were joint on the checking accounts and savings accounts and the brokerage account. We were joint owners on the house or the condo that we owned at the time. And we were beneficiaries of each other's retirement accounts and life insurance policies. So, and we haven't talked about a will yet, but I'm going to bring it up right now. Even if I had a will at my death, and my will said, everything goes to this wonderful girl, Pam Rakansky, who works at the YMCA. She's an awesome person. Even if my will says everything goes to Pam, nothing would go to her. And everything would go to my wife because of the joint ownership, because of the beneficiary designations. That supersedes language in my will. Okay. So not only does that supersede language in my will, but because we were joint owners, because my wife was beneficiary, she automatically gets all that at my death, no probate. The issue with a lot of married couples is when the second spouse dies. And obviously this is the same issue for a single individual that was never married. Because when that single person dies, inevitably they tend to have things in their name only. Now I meet with a number of single individuals or widowed individuals who come to me, and they think that they've done the right thing by adding their son and daughter as joint owners on all their accounts. Right? And the idea is, well, if something happens to me, there's no probate. And why do I need to do any planning? They're joint owners on all my stuff. So of course I'm like, why'd you even come to see me then? You know it all. You figured out your own plan. But there's a difference between putting a proper plan in place and avoiding probate. Right? What they don't realize is, what if your son gets a divorce? What if your daughter gets sued by somebody? Guess what? They're joint owners on all your stuff. Now you are liable. Now your bank accounts and your investments are liable for their issues. Okay. Same thing happens when clients come to me and they're like, well, we just recorded a deed and I added my son on title to my house. Again, that's great at protecting from probate, right? It's not going to go through probate. It's not going to go through court when they pass away. But again, what if something happens to your son? What if somebody comes after it? What if somebody sues him? What if he gets a divorce? And I know these things are far-fetched, but this is where, like, penny wise, pound foolish, I always forget the phrase, but you guys probably know what I mean by that. Is it worth it? Is it worth just adding your son as a joint owner because you're going to save a couple $100 or a couple $1,000 in your estate planning? But if something were to happen to him, you could be at risk for a couple $100,000. Probate isn't the end of the world. Okay. I would argue most people would prefer to avoid it. And I've been doing this long enough to know that the vast majority of people would prefer to avoid it, but probate's not the end of the world. If my estate goes through probate, here's what's going to happen. Okay. I'm assuming most people here live in Cook County. Even if you live in Lake County, it's very, very similar. It's not really different. I would say Cook and Lake are actually almost identical. You're looking at, if it's a simple estate, right? Maybe you own a house, a couple bank accounts, a couple investment accounts, whatever. If your estate goes through probate, you're probably looking at about average about a 12 to 18 or 24 month process. So anywhere from like 12 to 24 months, 1 to 2 years. Probably somewhere around $5,000 to $10,000, $5,000 to $12,000 in attorney's fees and court costs. And then I'm gonna just kind of throw out there, and of course I would throw this out there, a little bit of aggravation, right? Nobody loves going, and most people don't have to go to court, right? So if I'm dealing with probate because my mom died and I'm the one dealing with the process, I'm really not going to court. A lot of people think they'll have to go to court. The attorney deals with all that, but most people don't want to deal with attorneys. I'm one. I get how it works. Okay, we're not confrontational attorneys, but we're still lawyers. People don't like dealing with lawyers. Why? because they typically think, oh my God, lawyers are going to charge so much money. Okay. But in general, think about it this way. You just lost your mom or dad or brother or sister. Is it going to be enjoyable to have to deal with a lawyer and kind of go through this court process that you could be dealing with for a year to 2 years? Most people would probably say no. I'm not going to say probably. Most people would say no. Okay. But probate's fine. It works. People get through it. Estates get settled. Money gets distributed. And then they're done. Okay. I want to be very clear. A will, right? So I put a will together. My will says there's sort of two to three main things with a will that we use it for. Okay. One is, for most people, our first thought is, who are we leaving our stuff to? Right. So my will says everything goes to my wife if she survives me. If she doesn't survive me, it goes to my kids. Great. If my kids, so if I've got minor children, so if there's anybody on here that has minor children, so I have to also make a provision for guardians. Right. If my kids are under the age of 18 when I pass away, or my wife and I pass away, because obviously she would be their guardian, their sole guardian if I passed away. But if my wife and I don't survive our youngest kid turning 18, these are the guardians I want to step in. And I can name multiple people, this couple first or this individual first. And if he or she can't do it, then this person, this person, this person. So we're naming guardians, right? Who's going to take care of our kids if they're not 18? And then lastly, who's going to be the executor of my estate? Who's going to manage my estate? Who's going to deal with the probate process when I pass away? Well, typically, if people are married, typically they're going to name their spouse as their primary executor. But what if my wife doesn't survive me? Or what if she's incapacitated when I pass away? Maybe it's my dad. Maybe it's my mom. Maybe it's my brother. Maybe it's my sister. For those clients of mine that have adult children, typically they're going to name their spouse, and a lot of times they'll name their adult children as their executors, as long as their adult children are trustworthy. For those that don't have adult children they can rely on, or nieces or nephews they can rely on, or brothers and sisters they can rely on, we can name banks or trust companies. They'll charge a fee, but they'll step in and they'll manage things and they'll handle it in the right way. Now, I want to be clear. A will is not a document we use to avoid probate. I want everybody to know that. A will is not a document we use to avoid probate. A will, very opposite of that, and sort of the way that I phrase it, is a will is like a letter to the judge. Dear Judge, my name is Matt Margolis. I died. Here's what I want to have happen. A will only kicks in if my estate goes through probate. And that's why we kind of call it a letter to the judge. My estate doesn't go through probate. If I've got beneficiaries named on everything, or if I've got assets in a trust, which we'll get to in a minute here, then there's no probate. And my will that says everything that goes to Pam Rakansky, Pam gets nothing, unfortunately. And everything goes to the beneficiaries that designated on my accounts, or the joint owners that I own my assets with. The will is just there, really, to some extent, is like a safety net to catch whatever goes through probate and to make sure that it gets distributed in the manner that I want it to be distributed. Okay. So I know I'm kind of going back and forth a little bit, but with most married couples, just to reiterate, typically we don't see probate until that second spouse dies. And then in that case, it would be the will of the second spouse that would control where the stuff goes. Okay. Now let's talk about a trust. All right. So the type of trust we'll talk about today is what we call a revocable living trust. All right. And a revocable living trust is the most common type of trust out there. All right. There's different types of trusts. There are special needs trusts. There are irrevocable trusts. There's asset protection trusts. All that stuff's great. We do a lot of it. We're not talking about that today. All right. Today, it's the revocable living trust. This is the most common type of trust. I think I just mentioned that. Say it again. Okay. If you have any friends or family members that have a trust in place that have mentioned they have a trust in place, I'm going to go out on a limb and say 98% chance this is the type of trust they have. Okay. People use trusts for two reasons, for the most part. The most predominant reason people put a trust together is to avoid probate. It's not because they're wealthy. It's not because they're the Pritzkers. It's because they want to avoid probate. They want to avoid a public process that one of their loved ones will likely have to deal with for 1 to 2 years when they die. By using a trust, they can avoid probate. They can have their estate administered privately outside of court on the time of the trustee, and we'll talk about what a trustee is. But the people they're leaving behind, they can kind of manage it on their own time, not necessarily the court's time. Okay. Now we also do, now listen, there's people with a lot of money that use trusts, not just to avoid probate, but also to pay less estate tax. And I will touch on that for like 2 minutes, okay? Because it will be applicable to some people. But actually we don't even need to go in and talk about it in depth. We can kind of cover it very lightly, and I think it'll get the point across. So when I create a trust, let's say I create the Margolis trust. Now I can create a trust by myself, or I can create a trust with my spouse, right? So my wife and I can create a trust together, a joint trust. And we have the Margolis trust, right? And we are what's called the trust makers. And all these terms, you can think about it, whether it's a married couple or an individual, it's all the same, okay? We're the trust makers of the trust, right? That means we're creating it, right? Really original term, I know. We're the ones creating the trust. We can also make changes to the trust. So a revocable trust can be changed over time. It's flexible. Something in our life changes, we can change the trust, as long as we have capacity. All right, once we lose capacity, no more changes. We're done. Whatever the trust says, that's it. We are also the trustees of the trust. Trustees of the trust are who can control the assets that the trust owns. Okay, my wife and I would be co-trustees. Let's take a sidebar for a second and talk about what I just said. The assets that the trust owns. What does that mean? To avoid probate, it's not good enough for a client to come meet with me, for us to put a trust together, and then that's it. Okay, we're like 85% there. We will always, and most estate planning attorneys that do what we do, will always help clients retitle real estate, right? So if you live in Cook County, we've got a client that lives in Cook County, we're going to record a deed with Cook County transferring ownership of their house or condo to the trust, right? So now the Margolis trust owns our house, but my wife and I are the trustees. We can deal with the house just like we did before we had a trust in place. Zero impact on our daily life. And the trust operates off our social security numbers. So nothing changes from a tax perspective. We file our taxes the same way. I always tell clients, literally, it's like the IRS doesn't even know you have a trust. Doesn't matter to them. Okay. So we as attorneys will retitle the real estate. And if there's real estate in other states, we'll work with other attorneys in those states to make sure that real estate gets retitled as well. But when it comes to the bank accounts, right, the checking accounts, the savings accounts, the brokerage accounts, those accounts need to be retitled to the trust. Okay, now that's the responsibility of the client. So they have to make sure, and I can't say what other attorneys will do, but we provide guidance to our clients. And we say, okay, this is all the stuff you have. This is what you need to do with every single account. You need to go to Bank of America and retitle the checking and savings account. You need to go to your financial advisor at Wells Fargo and retitle your brokerage account. When it comes to IRAs and 401ks, those have to stay in our name. You can't retitle a retirement account to a trust. But in some cases, we might name the trust as a contingent beneficiary after our spouse. And every situation is different. We don't do that in every single case. A lot of times it might depend on the age of our children or of our beneficiaries after after everything would go to our spouse. But IRAs and 401ks stay outside the trust. Okay, important to know that. Important to understand that we can also name the trust as a beneficiary. And again, it's appropriate in some cases, it's not appropriate in others. Life insurance policies, again, those are typically going to stay outside the trust as well. We just want to make sure that we update the beneficiaries appropriately. So now back to my conversation about trustees. My wife and I are trustees of the trust. We just retitle all of our assets that can be retitled to the trust. Great. We can deal with all that stuff just like we did before we had a trust in place. We can still deal with our brokerage account at Wells Fargo. We can still write checks at our checking account at Bank of America, take money out of the savings account. Literally, your life does not change. The only thing that's going to change is when you get your statement from the bank, it's going to say Matt Margolis, trustee of the Margolis Trust, with your address, rather than just Matt Margolis with your address. That's it. Okay, biggest difference. But we need successor trustees, right? Because listen, if I pass away or am incapacitated, my wife will still manage the trust, right? She's my co-trustee. She'll still deal with everything. Just like if we were joint on a bank account with no trust, right? If I was incapacitated or I passed away and we were joint, she would still deal with it. It would be for her benefit. She has access to it. But what if something happens to both of us? What if we're both incapacitated? What if we both pass away? We know that will happen. Hopefully not for a long time, but we know that'll happen. So we need to name successor trustees. Kind of think of those successor trustees of the trust as executors of the will. From the standpoint of who do we want to step in? Excuse me. Who do we want to step in to manage our assets? If we're either alive but incapacitated or upon our passing. And we can name 2 people as co-trustees. We can name 5 people in order, one at a time. You know, I always say the more the merrier, as long as they're people that you trust, no pun intended. You know, some people have 5 or 6 people they can name as trustees. That's awesome. Some people struggle to think of one. But again, that's where we can name a bank, we can name a trust company. You know, there are corporate options, and I get it. People don't like the idea that a bank or trust company will step in and they're going to charge and yada yada. But if we don't have any people we can rely on or that we can trust, that's the route we're going to go in. When we talk about naming beneficiaries, right? So if we've got my wife and I have a joint trust, something happens to me, she's the trustee, the trust is for her benefit. Again, look at a joint trust for a married couple as being almost identical to if we had a joint account from a very practical standpoint. Something happens to me, it's all for her benefit, okay? Something happens to both of us, we need that successor trustee to step in, right? We passed away, we need that successor trustee to step in. And now we need that successor trustee to administer our estate, our trust estate. So that successor trustee is going to step in and sell the real estate, consolidate all the money. Okay, make sure all final expenses are paid. And at the end of the day, let's say there's $1 million and we're leaving everything to our 2 kids. Well, then the trustee is going to write a check to each kid for $500,000. And they can go off and do whatever they want, and we're done. Okay. So let's step back for a second. There's 2 ways that we can distribute money to beneficiaries, and whether it's our children or nieces and nephews or grandchildren or friends of friends or whoever it is, charities. Well, charities are a little different. If we're leaving money to a charity, we're leaving them money. Okay. Typically there's not different ways that we leave money to charity. But when we're leaving money to individuals, we sort of have 2 different options. We can leave it as an outright distribution. Outright means what I just talked about, right? So there's $1 million. Our trustee writes a check to each one of our kids for $500,000. They can do whatever they want. It's an outright distribution. They get a check. They do whatever they want. Now that typically works if we're leaving money to beneficiaries that we feel like are old enough and responsible enough to take that money and handle it and manage it. But for those of us that have younger kids, right? Our kids are 6 and 3. When we did our planning, our son was 2 months old. So we have options as to how we can leave them the money. And typically the way we're going to set things up, especially with minor children or minor beneficiaries in general, is that we're going to say, you know what, if something happens to us, and I'll give you an idea, this is what my wife and I did, but there's no right or wrong, okay? If something happens to us and our kids are not yet 30 years old, then when we both pass away, when it's time to distribute the money, there are going to be 2 trusts set up, one for our son and one for our daughter. And these are just trusts that spring out of our trust. These aren't separate documents we're drafting. Right? It's not like we're telling our clients, well, that's an additional $500 for every kid you have that we're setting up a trust for. 2 trusts come out of our trust, one for our son, one for our daughter. And my brother, let's just say my brother's the trustee. He's going to manage the money in these trusts for our kids until they turn 30. And he can use the money for their healthcare, their education, and sort of their general support. Most of our clients want the trustee to have more liberal discretion to use the money. What does that mean? That means that if our son asks Uncle Mike, the trustee, for a new car, and he really wants this Mercedes AMG and it's only $110,000, Uncle Mike can say, a used Toyota Camry sounds great. Let's go take a look, right? The trustee's not there to, and I tell this to every client, I don't want the trustee to step in, at least for us, right? And everybody's got their own desire. But for me and my wife, right, we named a trustee that we had that has similar values to us, because if something, God forbid, happened to us and our kids were young, we wouldn't want that trustee spoiling our kids. We want that trustee to take care of our kids just the same way that we did. In a perfect world, our kids are over the age of 30 when we die. And these little trusts that I just mentioned never get set up. And when we pass away, they're over the age of 30 and they each just get a check and they can do whatever they want. But we have this protection built in case they're young, right? We want to protect them against themselves. We have no idea how responsible or irresponsible they're going to be. And 30 to us just seemed like the right age, right? We were thinking of our friends and we were like, by 30, you kind of are who you are. If you're responsible at 30, great. If you're still irresponsible at 30, are you going to be that much more responsible at 35 or 40? I don't know. When we leave money to beneficiaries, we always have to consider what's going to happen if they don't survive us, right? I talk about it every day. Not a great conversation. When my wife and I were doing this planning, and she was 2 months postpartum, and I'm asking her, where would the money go if Luke didn't survive us? But we have to plan for that, right? So where would it go if one of our beneficiaries didn't survive us? And we can think about things that obviously we don't want these things to happen, but we can plan for things that we don't want to happen, right? What's very common for people is to say, well, if he didn't survive us, it would go to his kids, if he had kids. And if he didn't have kids, then it would all go to our surviving child. Or it would go in this direction. Again, estate planning isn't a one-size-fits-all type of deal. Everybody's got their own version of what works for them and what makes sense. Kind of last but not least, in the trust, we have what I refer to it as the Armageddon provision. It's technically called remote contingent distribution, but that's boring. So I say Armageddon. For my wife and I, Armageddon would be if at the time we died, we didn't have any children or grandchildren that survived us. So if all the beneficiaries we've named don't survive us, where does it go? Do we leave it to our brothers and sisters, our nieces and nephews? Is this where we all of a sudden get charitably inclined? Again, we're not here to make our clients go crazy and to make them think of all the worst things in the world, but I'd rather over plan and make them a little uncomfortable than under plan because I'm concerned about their feelings. And believe me, I mean that in the nicest way, I promise. I'm a big teddy bear. That's really how a trust works, okay? For the sake of time, I'm going to go back really quick and just talk about, so if we're looking to put a trust together, and not just to avoid probate, but also to protect our assets in case we have a taxable estate, okay? In case we have a large enough estate where we might be subject to estate taxes, then here's what we do. And just so everybody knows, in Illinois, you do not have a taxable estate unless you have more than $4 million, okay? Great problem to have. Majority of us do not and will not have this problem. Okay, but there are obviously folks out there that do. And actually more and more folks these days do have that problem than they used to, but regardless, it's still a small percentage of the population. So let's say my wife and I are fortunate enough to have a $5 million estate. Well, I can tell you, we would not use a joint trust. Okay, here's why. If we had a joint trust and I pass away first and now there's $5 million in the trust for my wife's benefit, and she passes away, even though we each have a $4 million estate tax exemption, I can't pass on my $4 million exemption to my wife. So it's not like she can take advantage of $8 million at her passing. It's individual to us. So at her passing, if there's $5 million in this joint trust, $1 million will be subject to estate tax before everything gets distributed to our kids. And let's just say that $1 million is probably gonna be taxed. There's various equations that they look at, but let's just say you're looking at like 15 to 25%. If we had two trusts, so the way that we would plan, or the way that we would recommend to clients to plan in that situation, is that we would create two trusts, not because we're looking to make things overly complicated. We are actually the opposite. There are a lot of firms that tell every client that they need two trusts. Doesn't matter if they have a $200,000 estate or a $6 million estate. We're not like that. We feel people can use a joint trust, keep it simple. That's what we'll do. But if we have 5 million, the idea is that we want to use two trusts, and here's how it would work. My trust, let's say we put $2 million of the assets in my trust, $3 million of the assets in my wife's trust. My trust operates off my social, her trust operates off her social. We would still be co-trustees of each trust though. So we would both still be able to control and have access to all the accounts and assets in both trusts. So it's not like we're giving up control. It's just that technically, some assets are under my wife's trust and some are mine. From a tax standpoint, here's what happens. I pass away, right? There's $2 million in my trust. I pass away. My wife is still the trustee. She can still manage the assets. She can still access them. She can still use them for her, the kids, whoever. But my trust will get a taxpayer ID number at my death. Now it's going to start filing its own tax return. It's its own separate entity. That money never becomes part of my wife's estate for tax purposes. So when she passes away, she's passing on $3 million. And because it's under the $4 million limit, it's tax-free. And then my trust passes on the $2 million. And it never got added to my wife's estate. Okay. So it's a really simple way actually to avoid paying estate taxes, but I can tell you that a lot of people don't do it. And it's not that we recommend it to a lot. I'm saying we recommend it to a lot of people, and they don't do it. I'm just saying that there's 70% of people don't do any estate planning. And there are obviously people in that 70% that have taxable estates. That's all I'm going to say on that front. Okay, we don't need to go too much further on that. Every time we create a trust, we always create a will that goes with it. Okay. So it's like every bourbon is a whiskey, not every whiskey is a bourbon. I don't know if you knew that, but now you do. Every time you create a will, you don't necessarily need a trust, right? Some people say, I just want a will. If I go through probate, I go through probate. So what? Fine, great. But every time you create a trust, we're always going to put a will together with it. We refer to it, and this is whether my wife and I create separate trusts or a joint trust. And whether we have separate trusts or a joint trust, wills are individual to us. There's no joint will. Okay. We kind of refer to this will as a pour over will. Like a pour over coffee. Okay. That's not what I'm drinking, but so a pour over will. And the idea behind it is this is like a safety net. Because here's what happens. People put trust together and sometimes they still go through probate. Why? Well, let's go like 20 minutes ago in this conversation when I mentioned, okay, we put a trust together. We help our clients retitle all the real estate they own. And then we provide very, very, very detailed guidance as to what they need to do with all their bank accounts and investment accounts. But I'm not walking with my client hand in hand into Bank of America to retitle their bank account. And I'm not saying that in a mean way. They just, believe me, they don't want to pay me to do that. Okay. And they don't need to. But the thing is, it's going to be up to them to take some steps. They've got to be proactive about making sure that they make these changes, because those changes are going to be what allows them to avoid probate. I can put the best trust in place for clients, but if they leave assets in their name only and they don't retitle them to their trust, they're going to go through probate. Or if they buy some second house in Wisconsin 20 years after I do their planning and they don't tell me about it, or they don't take title to the house in the name of the trust, and the house is in their name only, that house is going to go through probate when they die. So that pour over will, it's not a mechanism to avoid probate. but it's a mechanism to ensure that if something goes through the probate process, the judge sees the will and the judge says, two things happened. Matt died and he made a mistake. He didn't fund his trust appropriately. So this house or this bank account or this investment account that's going to go through probate, even though everything else might not, this one account goes through probate. At the end of the probate process, it's going to pour over into the trust, and then the trust will distribute it according to its terms. So the will is actually a very simple will. We name executors, and typically the executors in the pour over will are going to match up with the trustees that we named in our trust. We're going to name guardians. If we have minor children, that's where we're going to name guardians for our minor children. And then the beneficiary of my pour over will is the Margolis trust. I'm not naming all my beneficiaries in the will. It simply says the Margolis trust gets everything that goes through probate. And then my trust has all the details. Okay. So again, I'll say it again. It's a safety net that I hope we never use. Okay. All right, I'm gonna try to speed through the end here because I realize we got about 17 minutes and I want to leave some time for questions. So anytime we do any kind of estate planning, all right, there's gonna be a few other documents that really make up the plan. All right, now these are all, I want to be clear, these are all separate documents. So many people come to me and they're like, well, the power of attorney in my trust. I'm like, no, there's no power of attorney in your trust. These are all separate documents. But these are typically included in any kind of estate plan that's done. Okay, it's very uncommon for somebody to go to an attorney and say, I want a trust and a will, and that's it. So we look at powers of attorney for healthcare and property. All right, the healthcare power of attorney is a legal document where I'm naming somebody to make medical decisions for me in the event that I cannot make my own. I can name as many people as I want, but unlike a trust or a will where I can name co-trustees, right? Two trustees acting together or two executors acting together. On the power of attorney for healthcare, I can name 5 people, but they're one at a time. I cannot name people to act together, okay, one at a time. And of course, I need to be selective in who I'm naming, right? Some people, I think, just pass over powers of attorney. They're like, oh yeah, whatever, those are like simple documents. I'm just gonna print them online, no big deal. I mean, people should put some thought into this, right? Who's gonna make a medical decision for me if I'm incapacitated? Who's gonna step in and handle that? And listen, I don't want my life to be artificially prolonged. That's me. I'm being real. I probably want to tell the people that I'm thinking of naming. Number one, I want to make sure that they're comfortable stepping in for me. Number two, I want to make sure they're comfortable making my decision for me. Right? I might think that my daughter, right? I don't have an adult daughter, but I might think my adult daughter would be great, but maybe she would have a really hard time, pulling the proverbial plug, if that's what I would want, or not putting the plug in. So maybe I have to name my son, who's, got no heart and just willing to do whatever anybody says. And that's not my kids. I'm just making that up. But I say that because clients sometimes think like, oh, my daughter, she's so great. She's a nurse. She's got the heart of gold. I'm like, but this might be difficult for her, even if she sees it on a daily basis. Because your daughter, the nurse, might be able to remove emotion and do what needs to be done when it comes to her patients. But when it comes to her dad or her mom, it might be a different story. So again, we need to make sure we're naming the right people for the job. And I always tell clients, I'm like, and again, I really mean this stuff in the kindest way possible, but it'll come off a little harsh. I'm like, I don't care about you hurting your kids' feelings because you're naming your youngest instead of your oldest. My oldest son is going to feel so slighted if we name our daughter who's 5 years younger. I don't care. These are important decisions. You can't make these choices because you don't want to hurt somebody's feelings. That's not fair to you. Okay. The property power of attorney. The property power of attorney is who can step in and make all decisions for me that are not medical in nature and that are not dealing with assets that are in my trust. Because if I'm incapacitated, if my house is in the trust, if my bank accounts are in the trust, then my successor trustee will deal with that stuff. But my power of attorney for property would deal with things like my IRA or 401k. Remember, those are going to stay in my name. My power of attorney for property is going to deal with my life insurance policy. My power of attorney for property will be the one to file my tax return, sign a contract on my behalf. Okay, these are all issues that my power of attorney for property will deal with. And again, I can name as many people as I want. It's one at a time in a particular order. And I will say that in a lot of cases, the order of people that we name as trustee of our trust, executor of our will, and power of attorney for property, not healthcare, property, tends to be the same order. Inevitably, clients will be like, oh, well, yeah, my daughter's a CPA, so she'd be perfect for these roles. Or my son's a lawyer, or financial advisor, he'd be great. Maybe. I would tell clients, I do tell clients, not I would tell clients because I play a lawyer on TV. I tell clients that who's good at running a household? And that might be your daughter, the financial advisor, or that might be your son, who's a stay-at-home dad. Who's making sure the bills are being paid? Who's making sure taxes are being filed on time? Who's making sure that if something breaks, it's getting fixed? That's a good power of attorney for property. Somebody that gets stuff done, somebody that's resourceful. Your daughter, the CPA who works, 55 hours on a regular week and 80 hours a week during tax season may not be the best trustee or executor or power of attorney for property. Because if you die at the wrong time, they're not going to have any time to step in for you. And I'm not trying to be funny. I really want people to think about these things because people do. I try to add a little humor because, it's a serious topic and nobody wants to be serious all the time. But people need to think about these things because some people are just very quick to be like, well, I've got 3 kids. I'm going to name them in order of oldest to youngest. And I'm like, is that the right order? If it is, great. I will respectfully challenge my clients to make sure that they are picking the right people. Powers of attorney for property and healthcare, great, we got those. Last 2 documents that are a part of any estate plan, living will, HIPAA. Living will is the do not keep me alive unnecessarily document. This is not the same as a DNR or a POLST, which is actually a doctor's order and very, very controlling. We're not going to go into that right now. A living will is just more direction to my healthcare power of attorney that I do not want my life artificially prolonged. Okay, again, it is not the same force and effect of a DNR. The example I give is paramedics coming to my house and I've got no pulse, I'm not breathing, and my living will happens to be sitting on my chest. They're going to throw it off and they're going to give me CPR. They're going to try to keep me alive. Because the living will is not going to stop a paramedic from trying to save my life. The living will is going to be direction to my healthcare power of attorney that I don't want to be put on machines. That I want to be kept comfortable, but I don't want extreme measures to be used to keep me alive if I'm going to have no quality of life. Whereas the DNR, right? Let's say the paramedics bust down the door. I've got no pulse, I'm not breathing, and my DNR, it's now called a POLST, a practitioner's order for life-sustaining treatment, happens to be laying on my chest, and it says, "Do not resuscitate on there." Then they won't, and they'll let me die. Big difference between those documents. Okay, living will is not appropriate for everybody. I've got some clients for just their own personal reasons or for religious reasons that they will not sign a living will. They want their lives to be prolonged no matter what, no matter how bad it's going to be, no matter if they're going to have zero quality of life, no matter if it's going to cost, thousands and thousands of dollars, likely to no avail. So be it. And everybody's entitled to their own opinion. Nobody's wrong. But in those cases, they wouldn't sign a living will. Last document is the HIPAA. The HIPAA is the healthcare authorization. I'm sure most of you have signed some version of a HIPAA at some point. Maybe at your doctor's office, maybe you had a procedure done in the hospital. This is where I get to name people to have access to my medical records, to my medical information. This is not giving them decision-making authority, to be clear. That's the healthcare power of attorney. This is strictly access to information. So, and you can name as many people as you want in no specific order. So my HIPAA, to give you an example, has my wife, my parents, my siblings, my in-laws. Right, there's like 8 people on there. Anybody on there at any point in time, you go to my doctor and ask for copies of my medical records. I'm fairly confident none of them would ever do that. But I have to be comfortable that they could. The reason I really like the HIPAA, it's not so much from the medical record standpoint, right? I think most of us would agree that's pretty random. The likelihood of that being something that would help us is not likely, unless our family thinks we're trying to hide some illness, and then they could try to find out. But really, the reason why we like the HIPAA is if there's an emergency and I'm rushed to the hospital and I'm not responsive and I can't give permission, anybody on my HIPAA can call the hospital. They can go to the hospital. They can talk to the doctors. They can talk to the staff, and they can find out what's going on with me. So I like the HIPAA for that reason. It may never come up. Okay. But if it does, it'll be helpful. All right. That was a lot of talking on my part. It's 10:08. We've got 7 minutes. I will open it up for questions.
Any questions?
Sorry for my very abrupt ending.
Hi, Matt. Can you hear me?
It's
Kind
kind of.
well.
Yeah, can you hear me? I came in a little late. I was delayed. Will this be available as a recording?
Yes, it will
Okay.
upload it in about 2 hours.
Okay, great. The second question, I don't know if you covered it. What about overseas holdings?
Yeah, so there are some estate planning attorneys that can deal with that. I mean, like we're talking about like for like asset protection reasons, or are we talking about just you own real estate or
Property
assets
mostly.
in another country?
Yeah, property in another country.
Yeah, so I've got clients. I've had some clients over the years that they own a house in Greece or a house in Italy or Poland. We cannot deal with those properties with the planning that we do here. We advise them to work with an attorney or whatever that version looks like in that country to deal with that property. We can't handle it here. We can't handle it through
Okay.
our planning here.
Thanks.
Yeah, of course.
Looks like Jay has a question and Tony. Yeah. Jay, do you want to go?
Yes, thank you. Is there any way to protect your assets should you end up in a nursing home for an extended period of time?
The short answer is yes. I won't have enough time to go into any detail, but yes, and we do plenty of that.
Thank you.
He also has some other talks that we'll talk about that.
Yes, correct. There are other talks I give Jay where we cover that.
Tony, do you have a question?
Yeah, about an estimate of how much setting up a trust would cost. I know it would depend on your assets, but just a ballpark for a normal trust.
So it doesn't really depend on your assets, to be honest with you.
Oh, okay.
I don't charge more or less, for depending on what people have. But I will say, Tony, it's not something I have no issue sharing what our fees are, but I don't want to share it in a large group. So I'm going to put my info in the chat box.
Okay,
And you can feel free to shoot me an email, and I'm happy to answer it. I have no problem
perfect.
answering that question. I just it'd be easier if I kind of know your circumstance rather than
Okay.
giving you like a window that might not mean
Sure,
anything.
sure. And a revocable trust can turn into an irrevocable trust, right?
So when a revocable trust turns into an irrevocable trust, either at incapacity. So if I'm incapacitated, then it becomes irrevocable. And then when I die, it becomes irrevocable.
Okay,
You can't but other than that, you can't just decide to turn a revocable trust into an irrevocable trust.
it has to be triggered by something.
Correct.
Okay,
Yep.
that's it.
Yep.
Thank you. It was a
Yeah.
great talk.
Awesome. Thank you. I appreciate you sharing that.
Awesome. Any other questions? If not, Matt did put his information in the box, and I can try to send just another email out to the whole group about with the video posted. Other than that, thank you so much for attending today's talk. Thank you, Matt,
Yeah.
for talking about that. His next talk, I should have had this up, sorry. Sorry. Matt's next talk is April 5th, talking about navigating the long-term care maze. So please, you're welcome to join us on April 5th for navigating the long-term health maze. Other than that, our next talk is on Thursday, March 9th. We're talking about understanding Alzheimer's and dementia with the Alzheimer's Association of Illinois. So you're welcome to join us there. Otherwise, we will see you hopefully in April for another one of Matt's talk. Thank you, everyone, and have a great day.
Thanks, guys. Thanks, Pam.
Thank you.
Thank you.
Bye.
Bye.